In this lecture, we will look at the doctrine of merger and the rule of stare decisis. Okay, so we'll see why they are in news, plus what are these two concepts. It is of course related to your polity. The Supreme Court has mentioned about this, so let us see what they are, why are they in news, and some examples of it. Okay, so why in news? First things first, the Supreme Court has emphasized. What is has emphasized? Supreme Court has exceptional powers. Exceptional powers under Article 142 of the Indian Constitution. So giving reference of exceptional powers under Article 142 of the Indian Constitution, it has said that it has given actually an exception to the doctrine of merger. The Supreme Court itself has given an exception to the doctrine of merger and the rule of stare decisis. Now, what does this statement of Supreme Court means? It means that, see, there are two things. One is doctrine of merger, which is generally applied. The other is the rule of stare decisis, which is also generally applied. Now, these rules, the rule of stare decisis is not documented. It is not no guidelines as such, but it is followed. Okay. So, the Supreme Court said that under its exceptional powers under Article 142, it is not necessary, it is not compulsion, it is not a compulsion on the Supreme Court to follow the doctrine of merger or to follow the rule of stare decisis, right? So under Article 142, Supreme Court has given itself an exception for what? For the doctrine of merger and the rule of stare decisis. Why? It says that by doing so, it aims to achieve complete justice, because it says that if these rules are always all the time applied, it may be possible at times that complete justice may not be given, and hence there needs to be an exception to these two doctrines under Article 142. So now let us look at what these two things are. So what is doctrine of merger? Now, doctrine of merger, to understand this, let's understand that a lower court has given a judgment on a particular case. So when a lower court has given a judgment on a particular case, so there would be the judgment and there would be a reason for that judgment. The reasoning would be there. Now, if any of the aggrieved is not okay with it, they can appeal. So this is a lower court. Now this judgment may go to the appellate court. Appellate court would of course be a superior court than this particular court. Now they may also give the judgment, right? And they may also give the reasoning, right? So the doctrine of merger says that, see, if this judgment and this judgment are different, then generally this reasoning and this reasoning will also be different. So what are the possibilities? The possibilities are the judgment itself is different. The moment the judgment itself is different, reasoning would of course, logically speaking, would be different. So this court's, lower court's judgment and reasoning would be null and void, and the superior court, the appellate court's judgment and reasoning would hold true, correct? But it can so happen that the judgment, whatever the judgment was of the lower court, the same judgment is there of the appellate court also, right? So now the judgment of this court is upheld by this particular court, appellate court. So the judgment remains the same. But even if the judgment is the same, it is possible that the reasoning can differ. They can give reasoning 1 and they can give reasoning 2. In such a scenario, these two judgments and reasoning needs to be merged. And what would be the final outcome? The final outcome would be the judgment, which is same, plus reasoning 2. Plus reasoning 2. This would be the outcome. It would be merged and the outcome would just be the judgment which was common. The judgment which is common for both the courts plus the reasoning of the superior court will come, right? But reasoning of the lower court can also be added here, plus the superior court can also add the reasoning of the lower court after approval. By approving it, it can approve. It can either have the same reasoning. If the reasoning is also same, there is no doctrine of merger required. But if the reasoning is different, then as per doctrine of merger, either only the appellate court's reasoning would be entertained, or appellate court's reasoning plus the reasoning of the lower court can also be applicable, but only after the approval of the appellate court. That is the doctrine of merger. Let us see. Doctrine of merger is found in the principles of court, decorum and propriety. Okay? It maintains the decorum of the court and all. Superior court's reasoning is given precedence, right? This it holds that when an appellate court issues an order, lower court's order becomes absorbed into it. So lower court's order is absorbed into it, and the final order will be coming out from the appellate court, right? So this, because of this principle, there is clarity. There is no dual judgment that was the judgment of the lower court, this is the judgment of appellate court, nothing like that. It gets merged and a final output comes out. But the final output can be judgment plus only the appellate court's reasoning, or judgment plus appellate court's reasoning and the reasoning of the lower court also, but only after it has been thoroughly approved by the appellate court. Okay? Now this is what the doctrine of merger is. Now what can be the example of doctrine of merger? Now let's say there is a case wherein subordinate forum, or forum as in the subordinate court, passes an order, okay, and the same is being dealt by a superior court. So lower court has passed an order, superior court is now dealing with that order, and it confirms the judgment, but for reasons different from the one assigned by the subordinate court. So it gives a judgment, but the reason, as I said, is different from what the subordinate court give, right? What would merge now in this order? What would merge? The judgment would merge because they are the same, right? What would merge in the order of the superior forum is the operative part. Operative part as in the part which would be executed, that is the judgment. Operative part of the order, and not the reasoning. The reasoning will not merge directly. You cannot give whatever the reasoning of the lower court was there plus whatever the superior court's reasoning is there. You don't do that. You give superior court's reasoning. If you have to include the, so that is the doctrine of merger. But if you have to include the reasoning of lower court also, then that is done after thoroughly approving that particular reasoning, right? In certain cases, reasons for the decision can also be said to have merged in the order of the Supreme Court if the superior court has, while formulating its own judgment or order, either adopted it, either it also gave that reason, or reiterated the reason that said that yes, this reason is correct, right? Or recorded and express approval. So either the superior court also had that as one of the reason, or the superior court also reiterated that yes, this is the reason, or it has approved of the reasoning. Then it can be also merged, or else it will not be merged. So that is your doctrine of merger. Now what is stare decisis? Stare decisis. When it comes to stare decisis, what happens is, if you read the definition, doctrine of stare decisis mandates that the courts adhere to prior judicial decisions. So, you might have seen in various movies or series when the lawyers are fighting cases, they give reference to the earlier case, the older case. Okay, my lord, this is what happened in that case and this is what the judgment was. Okay, so the judge will pay heed to that. But there is one thing. You can pass these judgments, these references in a lower court with respect to the judgments given earlier by the higher court. So in that case, then this lower court has to pay heed to the judgments of the higher court which has been given. So the precedence which has been set by the higher court will take precedence in the lower court, and the judge has to pay heed to that thing. Okay. Now in Supreme Court, Also you can do such arguments, but then you have to give an argument of a bench which was equal or which was a superior bench. So that is what you basically are giving precedent references to the precedents that has already occurred. The principle, it is the principle that lower court rulings should be governed by precedent rulings of the higher court. So if the higher court has in previous judgment said, let's say a particular incident or a particular activity is, let's say, criminal, that's what the higher court has said in its previous judgment. Now the lower court cannot decriminalize it because a precedent has already been set by a higher court. So what is stare decisis? It is a principle that lower court rulings should be governed by the precedents rulings of the higher court. They have to pay heed to the precedents of the higher court. Okay? So this is what your doctrine of merger and stare decisis is. The question may just ask the meaning. The question may just ask the article under which the Supreme Court has said that there would be an exception to these doctrines and rules. So all this becomes very important for your prelims examination. Thank you.